Today, a federal judge appointed by President George W. Bush, a judge named Ronald B. Layton, ruled that Air Force Major Marjorie Witt is, quote, constitutionally entitled to reinstatement to her duties as an Air Force flight nurse after she was fired years ago under Don't Ask, Don't Tell. Another day, another bombshell federal court ruling against a policy that now feels like it is teetering on the edge of existence. Even with big majorities of Democrats and big majorities of independents and even big majorities of Republicans saying they want to kill this policy, politicians don't seem to be able to get it together to kill it. Are the courts beating them to it after, lo, these many 17 dumb long years? Joining us to help answer that question is George Washington University law professor Jonathan Turley, who blogs at jonathanturley.org. It's good to see you, John. Thanks for joining us.
Hi, Rachel.
How important do you think this ruling is in terms of the immediate future of the Don't Ask, Don't Tell policy?
You know, Rachel, the Witt Standard, as it's called, is enormously important. It may actually be more important than the real blockbuster decision a few weeks ago, finding Don't Ask, Don't Tell to be just fundamentally unconstitutional. The reason is that earlier decision, you could find Court of Appeals judges who are uncomfortable with just saying that it cannot be done as a constitutional question. But what the Witt Standard does is it would effectively kill this policy under the weight of a standard that quite reasonably says, look at the individual. If you're going to say this individual is a threat to unit cohesion, prove it. And what was fascinating about this case and Judge Layton is that after he was reversed, after he ruled against her, he had a 2-week bench trial. And in those 2 weeks, he found what he clearly thought was profound evidence that not only was this not a danger to unit cohesion, but that the real danger was the removal of this talented nurse.
It's interesting to me when I was trying to follow the legal chain of reasoning here, because we do have this interesting case in which you've got the same federal judge ruling on the same individual twice, and his rulings went 2 different directions. He initially ruled against Margie Witt. Now, upon getting essentially legal direction from the appeals court, telling him to think about it in a different way, use a different rationale, a different standard, he ruled in the opposite way. The justification for the appeals court telling him to rule a different way is that they said they were following Supreme Court precedent in Lawrence v. Texas, another landmark gay rights ruling. Are all of these rulings sort of coming out of a fundamental change about gay rights and civil rights issues in the federal court system?
I think they are. And, you know, Rachel, the most elegant aspect of all of this is that it's very, very easy to dismiss cases against gays and lesbians as some faceless, monolithic body. It's much, much more difficult when you have to face a person, a talented and patriotic person who's doing a very important job. And I think that's what is so elegant about this decision, is that when you actually took the time to find out who Witt was and what she did, the outcome was inevitable. And I think that your point is still a very good one, that it does appear to be the courts that are most likely to address this policy, which has always been built on what can be described as a not so noble lie, that, you know, that gays and lesbians are a threat to military readiness. And this case puts the lie to that assertion. But it also, Rachel, is very similar to what we saw with the civil rights movement in terms of African Americans, that Congress has never been particularly brave in terms of constitutional rights or civil liberties. The courts have often stepped in, and with the civil rights movement, it was the courts that simply decided not to wait any longer and handed down decisions like Brown v. Board of Education. And this seems to be following the same trend, where you have a coalescing of federal judges who are saying enough, that we can't continue to blindly impose this discriminatory policy.
If the politics can't happen on this, if despite the White House's assurances to people who want to see this policy gone, that they'll get rid of the policy politically somehow, if that can't happen, this really does get worked out in the courts. Are we eventually heading toward a Supreme Court showdown on this issue? And is there any way to foresee what the conservative Roberts Court would be like as a venue for this challenge, making it all the way?
Well, the expectation is it would come down once again to Justice Kennedy, who is becoming a court of one on these issues, unless the court changes significantly. And we have to, and it could come to that. I mean, the Obama administration is moving to roll back on the victory earlier against Don't Ask, Don't Tell. They are trying to get that victory essentially negated in most part. And so you have not just the administration not helping, but in this case hurting. What they're not doing is what Governor Schwarzenegger did, what Attorney General Brown did, which is to say, look, we had a duty to defend a statute, but we're not going to appeal it because we happen to agree with how the court came out. The Obama administration appears not to be doing that.
Jonathan Turley, law professor at George Washington University, putting as fine a point on things as we need to hear. Thank you, John. It's good to see you. Thanks.
Thank you, Rachel.